Welcome to Law in Simple Terms. I'm Terry Ingram, founder of the Foundation for Public Awareness. Writing your own writ of habeas corpus from jail. To initiate the proceedings, the person in custody must prepare a petition for writ of habeas corpus. Keep in mind that preparing the petition does not entitle the prisoner to discharge, only to judicial review of his or her confinement. And if confinement is not lawful, then immediate release. The petition may be handwritten on any paper whatsoever. The prisoner must demand a paper and pencil upon which to write the petition. It is a constitutional right that you receive paper and pencil from your captors in order to write a writ of habeas corpus. In Florida, if they fail to do that, there's a $300 civil fine against them. And then, of course, you have a Title 42, Section 1983, which is a civil rights action to file against them for deprivation of your civil rights. Once complete, the petition must be served by you, by the prisoner, upon any of his jailers. Upon serving the petition upon any jailer, it is deemed filed at that moment pursuant to the mailbox rule. The petition must state at a minimum the caption of the court having jurisdiction over the writ of habeas corpus. Example, in Florida, where I'm from, were I to be incarcerated, I would have to state on the top center or the top right of my paper, in the Circuit Court of the 17th Judicial Circuit in and for Broward County, Florida. If you're in Ohio or California, then your jurisdictions would be apropos. Now, if you don't know the exact judicial circuit that you're in, then simply use the county and the state. Sacramento, California, whatever the case may be. The next is a place for the clerk of court to list the case number. So you simply write in the word case number and provide a blank space next to it. You do not put a case number in this area. That's very important. You understand this is an original action. It is a civil action. The writ of habeas corpus is a civil action, even though you've been charged with a crime. You do not put your criminal case number down here. If you do, you void the authority of the writ of habeas corpus because you're making it only a motion. It has its own case number, and it's free in Florida anyway. Should be everywhere else. It's free of charge, without cost, to file this. So again, no case number. The clerk of the court will put the new civil case number in the space you provide. The next is the name of the petitioner and the respondent. You are the petitioner. Your jailer is the respondent. For example, Terry Ingram or John Doe would be the petitioner. This goes on the left side of the paper, just under the jurisdictional statement and across from the case number. Versus Broward County Sheriff. Now, if you're arrested by the Davie Police Department or the Hollywood, Florida Police Department or the LAPD or whatever the case may be, you do not direct this habeas corpus to those people. You direct this to your captor. The one who has you in custody is the one that you serve your habeas corpus upon. If you're in a federal prison, you would serve this on the agents of the federal marshal. And the federal marshal would have to bring a return to court. The next is the title of the pleading. The title of your pleading will be Petition for Writ of Habeas Corpus. If you would like, under that, you may put Original Writ or Original Jurisdiction. Okay, it's an original writ. It is not part of your case. I can't emphasize that enough. It is not part of the case that you're in jail for, or even if you're out of jail, you don't use that case number. This is a separate civil action, and it's free of no charge in Florida anyway. Now, next would be the cause or the pretense for your imprisonment. For example, petitioner Terry Ingram is being unlawfully held in the Broward County Jail on charges of simple battery by the Broward Sheriff's Department, who refused to permit Terry access to bond and or pretrial release and or to be placed in front of a judge or magistrate. So again, you need to state the reason that your incarceration is invalid. One very valid reason is you are innocent until proven guilty. Why are you in jail? In the vast majority of the cases, people who are under arrest are entitled to be released on their own word, on their own bond. It's called a recognizance bond. So most people are entitled to a recognizance bond. If they don't want to release you, then they should put you up in the Hotel Hilton in the presidential suite, because you are innocent until proven guilty. If you're found guilty, then I have no problem with being put into a prison. But until that point, you are an innocent person. Why must you be punished by spending time in jail before you're convicted of a crime? That's why the Eighth Amendment exists. So this statement here is an Eighth Amendment statement. Excessive bond. They can't also place a bond on you that is excessive. So a bond on me for $100,000 or a bond on you for $100,000 may be a huge difference. You may be able to afford it. I can't afford it. So it's the same thing as putting no bond at all on me. What if they made all bonds $1 trillion? Well, then nobody would be able to bond out of jail, would they? That's the point of the Eighth Amendment. Now, the grounds upon which you claim this to be illegal. My example statement here is that the allegations of simple battery were made by a person, a witness, John Doe, to an officer, Deputy Smith. And such actions, even if they're true, did not occur in the presence of the arresting officer, and therefore there were no grounds for my arrest by Deputy Smith. So in other words, Jane Doe tells Deputy Smith that I hit her in the face. Deputy Smith sees a bruise on her face, and he arrests me. That's a simple battery. It is a misdemeanor not committed in his presence. He is not entitled to incarcerate me. Jane Doe must go down and take a warrant out for my arrest. Then Deputy Smith can come and serve it and put me in jail. Until then, he has no right to do that. If it's a felony, it's a different story altogether. Relief sought by the prisoner. For these causes, I move any judge of any court to have the respondent, my jailer, show cause why he's depriving petitioner, me, of my liberty, and to release me forthwith, now. You sign the petition and date the petition. Okay, now I have a video on my website that's almost an hour long that explains in great detail the habeas corpus, and I give an example of my own habeas corpus that you can look for. You must purchase this video. However, the video that you're looking at now has all the information that you need. If you want to do it yourself, go ahead and do it yourself. If you would like to support me, then you can go to my website, lawinsimpleterms.com, and you can purchase it there. If not, this will do you just fine. Thank you for supporting the Foundations for Public Awareness. Please feel free to visit my YouTube channel by clicking on the Terry's YouTube button on the homepage of my website.